Welcome to Mayer Brown's webinar entitled Going Dark in the United States, How to Exit the U.S. Public Markets and Options for U.S.-Listed Chinese Companies. This is Jason Elder. I'm a global leader of the firm's capital markets team, and it's my pleasure to welcome you to this webinar. Thanks very much for dialing in today. I'm joined by my partners Tom Kohler and Billy Au. We are all based in Mayer Brown's Hong Kong office, and each of us will be presenting a portion of our materials. Before we get started, a few matters of housekeeping. First, this webinar has been certified by the Hong Kong Law Society for 1 CPD point and also qualifies for 1 New York CLE credit. If you would like credit for this webinar, please print the affirmation form which was emailed to you earlier and can also be downloaded in the bottom right portion of the screen. You will need to attend the full duration of the webinar to receive credit, and we'll be reading a code during the webinar, so please do listen for that code and write it down. Just send us the affirmation form together with your evaluation feedback within 3 working days after the webinar, and we'll arrange for your credit. At the end, we will be taking questions from the audience, and you can submit your questions in writing using the questions box in the right column to the side of the slide presentation. We'll either respond to them at the end, depending on how much time we have, or contact you after the webinar to follow up individually. So with that brief introduction, let's get started. In this webinar, we'll be discussing the legal and practical considerations around delisting and deregistration from the U.S. markets. There's been a considerable amount of news coverage and discussion fueled by the proposed legislation in the United States, which has the somewhat awkward name of the Holding Foreign Companies Accountable Act. We've been receiving a large volume of questions about how this could impact U.S.-listed issuers from Asia, particularly issuers based in China. Will this cause an increased number of secondary listings and homecomings? We've seen a number of these secondary listings complete successfully in Hong Kong over the past several weeks. So does this represent the beginnings of a larger trend? We will try to dust off the Mayer Brown crystal ball during this session and provide some of the answers to where we think that's going. After discussing the proposed legislation, I'll spend a little time summarizing the basics of going private transactions and share repurchases. I'll then turn it over to Tom to discuss the delisting and deregistration process from a U.S. market angle, and then Billy will finish with a discussion about secondary listings in Hong Kong, and we'll reserve some time for questions at the end. From the registration list, I see that we have a pretty wide range of experience levels attending today, which is great. We will plan to keep this high level, but are happy to follow up with you individually after the seminar if you have specific questions that go deeper than what we're covering for this broad audience. So as to the background and context for the discussion, what started this very active discussion around delistings from U.S. markets and whether PRC-based companies should consider a secondary listing in Hong Kong or elsewhere? The U.S. markets remain, as everyone on the phone knows, very deep pools of capital with excellent analyst coverage, especially in new economy sectors such as biotech, pharmaceuticals, online businesses, and technology. The liquidity is strong, and aftermarket trading has typically been orderly and predictable. And so we've seen a number of PRC-based companies select the United States as their primary market for precisely these reasons. However, against the backdrop of rising U.S.-China tensions centered primarily around trade, recent proposed legislation in the United States has forced market participants and CFOs to start considering their mid- to long-term relationship with the U.S. markets. Senate Bill 945, the Holding Foreign Companies Accountable Act, which I'll refer to as the Act in this webinar, along with rising tensions between the United States and China, presents significant challenges for U.S.-listed Chinese companies. In today's discussion, we'll be talking about the key ways that the proposed legislation could impact PRC-based issuers, and also discuss 4 considerations for U.S.-listed companies considering an exit from the U.S. public markets, including take-private transactions, delisting from U.S. securities exchanges, deregistering a class or classes of securities registered with the United States Securities and Exchange Commission, and secondary listings in Hong Kong, which could later become the company's primary listing venue following a delisting in the United States. On May 20th, 2020, the U.S. Senate unanimously passed the Act. The Act is an amendment to the Sarbanes-Oxley Act of 2002. As proposed, it would prohibit foreign issuers from delisting and trading their securities on any U.S. securities exchange or through any other method regulated by the SEC, if authorities in the foreign issuer's home jurisdiction prohibit the Public Company Accounting Oversight Board, or the PCAOB, from inspecting the issuer's registered public accounting firm. So, put more simply, if the PCAOB can't inspect the audit firm certifying the issuer's financial statements, then disclosure would be required by the SEC to investors, and ultimately penalties would be imposed. Statements made by the Act sponsors and the text of the Act itself indicate that the Act was aimed at U.S.-listed companies with China as a home jurisdiction. Before talking about the potential impact, it's important to remember that this legislation has not been passed yet, and it could be substantially revised as it moves through the process of enactment. We will talk more about the legislative process in a little bit more detail on a later slide. So first, why is the Act an issue for U.S.-listed companies from China? The proposed legislation puts U.S.-listed Chinese companies in a difficult position where compliance with the new rules might be impossible. This is because various Chinese regulations effectively prohibit foreign regulators, including the PCAOB, from inspecting public accounting firms based in China. Absent an ability for the inspection of public accounting firms in China by the PCAOB, the proposed legislation would automatically start imposing penalties that would jeopardize the U.S. listings of PRC-based issuers. Of course, PRC authorities could change the rules to allow for such inspections, but as things stand now, we consider that possibility to be remote at best. Most PRC-based companies that list on U.S. exchanges do so through Cayman Island vehicles or other offshore entities due to Chinese foreign investment and other regulations. However, the financial statements included in the IPO registration statements are audited by PRC-based auditors because the base of operations is not, unsurprisingly, mainland China. Accordingly, Cayman Islands or Chinese companies that list on the New York Stock Exchange or are quoted on the NASDAQ are directly impacted. As you know, these exchanges include many high-profile Chinese internet and technology companies, as well as Chinese companies from other growth sectors. As I mentioned earlier, there's various options that U.S.-listed Chinese companies will need to consider, such as going private, delisting and deregistering, and secondary listings in a jurisdiction outside of the United States, such as Hong Kong. We are encouraging our clients to consider these options sooner rather than later, as they require significant lead time to execute. So let's take a few minutes and get into the substance of the proposed legislation in the Act. What does the Senate bill contain currently, bearing in mind that this is still in draft form? A key part of the proposed legislation is the disclosure requirements that are contained therein, and this slide sets those forward. We can talk about these for a minute. By imposing an issuer disclosure obligation, the Act would require the United States Securities and Exchange Commission to identify issuers of securities on U.S. securities exchanges that retain a registered public accounting firm that has, one, a branch or office located in a foreign jurisdiction, and two, where the PCAOB is unable to inspect or investigate completely because of a position taken by an authority in the foreign jurisdiction. This is especially troubling for U.S.-listed Chinese companies because various Chinese regulations effectively prohibit the inspection of public accounting firms based in China by foreign regulators, including the PCAOB. The Act also requires issuers to submit to the SEC documentation that establishes that the issuer is not owned or controlled by a governmental entity in the foreign jurisdiction where the issuer's accounting firm has a foreign office. Under the proposed legislation, issuers identified by the SEC must allow the PCAOB to inspect or investigate the issuer's registered accounting firm. If the issuer fails to allow the PCAOB to conduct an inspection for three consecutive years, the SEC shall prohibit the issuer from being traded on a U.S. securities exchange or through any other method regulated by the SEC, including the over-the-counter trading of securities on the OTC market. The trading prohibition may be removed by the SEC if the issuer certifies it has retained a registered public accounting firm that the PCAOB has inspected to the satisfaction of the SEC. But if the issuer fails to comply again, trading will be suspended for a minimum of 5 years. In addition to these draconian suspensions of trading, there are important proposed disclosure elements for issuers. This slide sets those out. As proposed, the Act would require that in any year when an identified issuer uses a non-PCAOB inspected accounting firm to prepare its audit report, the issuer must disclose certain information in its annual report. This information includes the following: that the non-PCAOB inspected accounting firm prepared its audit report, that the percentage of shares that the issuer owned by governmental entities in the foreign jurisdiction where the issuer is incorporated or organized, whether governmental entities in the foreign jurisdiction of the accounting firm have a controlling financial interest in the issuer, the name of each official of the Chinese Communist Party who is a member of the board of directors of the issuer or the operating entity with respect to the issuer, and whether the corporate formation documents of the issuer contains any charter of the Chinese Communist Party, including the text of any such charter. So what's the likely timing for the Act to become law? Well, it's hard to say exactly, but we believe that it's going to take some time before any changes become effective. We reached this conclusion because there are several steps that remain before the proposal, in whatever form it eventually takes, becomes a requirement that PRC-based companies listed on U.S. exchanges need to address. As a procedural matter, a bill with the same language, which could ultimately be amended, was introduced in the United States House of Representatives on May 20th of this year, but that is yet to be scheduled for a House vote. The House would need to pass the bill before it's presented to the President to veto or sign the law. On June 4th, President Trump requested the Secretary of the Treasury, along with select presidential working groups, to prepare a report on the PCAOB access issue, as well as investor protections more broadly. The report from the presidential working group is expected to be issued by August 3rd. If legislation is enacted, on some date presumably following the report from the presidential working group, any subsequent legislative activity, and any reconciliation process between the Senate and the House, the Senate would have 90 days to issue rules regarding the disclosure and documentation requirements. Put together, this probably means that the rules would not come into effect until early 2021. And remember that there are a number of other open issues between the United States and China right now that are consuming bandwidth. And also the U.S. is heading into the final months of the presidential election cycle in November. So there's a lot going on, and it's hard to predict exactly when these changes might become effective, but it's unlikely that they'll become effective for the rest of this calendar year in 2020. In the current draft of the legislation, a U.S.-listed Chinese issuer would have up to 3 years before non-compliance with the rules would compel a delisting. However, it's important to start to consider options now so that if the legislation is enacted, there will be adequate time to implement a plan for any U.S. public equity and ongoing U.S. regulatory and compliance obligations. Various options available to a U.S.-listed Chinese issuer include going private, voluntarily delisting, and deregistering, and creating a secondary listing outside of the United States. One major difference with a going private transaction compared to other alternatives is that it generally involves cashing out public shareholders so that the issuer becomes eligible to delist and deregister its shares under the United States Securities and Exchange Act of 1934. These transactions require significant capital and time commitment, as well as compliance with tender offer rules and regulations. The term going private refers to a transaction or series of transactions whereby a controlling shareholder, significant shareholder, or other affiliated persons decreases the number of shareholders of a public company, thereby allowing the issuer to terminate its public company status and related reporting and compliance obligations under the Exchange Act and the Sarbanes-Oxley Act. The proposed amendments to the Sarbanes-Oxley Act and the compliance challenges it represents, as discussed earlier, make going private a very real possibility for U.S.-listed Chinese companies, particularly for companies with the capital and resources to do so. Going private transactions commonly take the form of a negotiated share acquisition by a controlling shareholder, significant shareholder, or other affiliated persons, or a repurchase or public tender offer for shares. Looking at the big picture, delisting in the United States isn't as easy as simply pulling down the ticker symbol and stopping compliance with Exchange Act disclosure requirements. The U.S. regulations aim to protect public investors in the listed company securities, So rules relating to how the public company goes private and how investors are treated in that process must be followed. So let's talk about a couple of types of going private transactions. A negotiated share acquisition. In a negotiated share acquisition, a controlling shareholder, significant shareholder, or other affiliated persons acquires the outstanding public shares of an issuer through a negotiated sale. The process of acquiring a public company may trigger obligations under U.S. federal securities law, and it's important to be aware of those obligations at the outset to avoid any unintended consequences. For example, the acquirer may have disclosure obligations soon after any offer is made under Section 13D of the Exchange Act. Rule 13E3, beneficial holders of more than 5% to disclose their intentions with respect to a share acquisition. In other words, are they just a large investor, or do they have a bigger plan with the purchase, for example, a going private transaction? In addition, the place where the issuer is incorporated may also impose special obligations on the board of directors when considering and negotiating the offer to purchase, and these corporate laws and regulations must be considered as part of any good planning process. We would note that litigation is not uncommon in going private transactions, so it's important to map out the entire process at the beginning, considering the situation from all angles, including from the company's angle, the board of directors' fiduciary obligations, what public shareholders expect, and any outside financing parties. And these all need to be considered when you're putting the plan together and before proceeding. We've included a few recent going private transactions, as examples in the following slides. These materials will be available on our website if you want to spend more time with them. They contain simple timelines with key milestones related to recent deals for 58.com, BitAuto, China Biologic, and those will be available if you want to spend some time with them after the presentation. An issuer may also decide to conduct repurchases through open market purchases or public tender offer process. For open market purchases, a market-oriented repurchase of public equity can be done in a number of ways. For example, the issuer may engage a financial intermediary to negotiate and execute open market repurchases, or it could agree with a financial intermediary to repurchase shares that the financial intermediary purchases on a principal basis. An open market repurchase of shares is effective if the issuer is seeking to repurchase only a small percentage of shares or if the shares are not widely held. An issuer repurchasing U.S. registered securities does run the risk of inadvertently triggering the U.S. federal tender offer rules, so it's important that the trades are structured properly. The tender offer rules ensure that the issuers and others conducting the tender offer don't engage in manipulative practices. So to avoid triggering an inadvertent tender offer under the U.S. federal tender offer rules, the trades should be structured for a limited number of shares to a limited number of holders over an extended period of time with no pressure on the holders to sell, at prices privately and individually negotiated, and with offers and acceptances independent of others. All major financial institutions should be aware of these issues and would be expected to appropriately structure the transactions to include these features. Assuming that the shares are widely held, though, or open market repurchases just aren't practical or commercial, how does a public tender offer work? A public tender offer is simply an offer to purchase from holders all or a portion of an issuer share for cash. The advantages of a tender offer include allowing an issuer to capture a large part of the outstanding U.S. public equity. The documentation is relatively straightforward, and the offer process can be completed in a short time frame, usually within 30 days. Typically, an issuer will engage an investment bank to act as a dealer manager to manage the overall process. Under the U.S. federal tender offer rules, tender offers must be held open for a specified time period, typically 20 days absent any interim modification of terms, and must comply with a few other conditions, such as tendering holders being paid promptly within 3 business days after the tender offer concludes. Once the shares are repurchased, the issuer will need to go through the delisting and deregistration process with the relevant exchange and the SEC. For a discussion on the delisting and deregistration process, I'd like to turn things over to Tom Cullen.
Thanks, Jason. So in the next few minutes, we're going to talk about delisting public equity from a U.S. national security exchange, such as the New York Stock Exchange or NASDAQ, and deregistering a class of securities from the SEC in order to terminate or suspend your public reporting obligations under the Exchange Act. Delisting and deregistration, also referred to as going dark, are related but separate processes. Both need to be undertaken in order for an issuer to suspend and terminate its reporting and compliance obligations as a U.S.-listed issuer. Delisting is withdrawing or striking your listing from a U.S. national securities exchange, such as the New York Stock Exchange or NASDAQ. Deregistration is withdrawing a class of securities from registration with the Securities and Exchange Commission and terminating and or suspending reporting obligations under the Exchange Act. Before we go into the mechanics of how you actually delist and deregister, let's step back and explain how exactly an issuer becomes subject to Exchange Act reporting obligations in the first place. An issuer becomes subject to Exchange Act reporting requirements if it has a class of securities registered under Section 12 or 15D of the Exchange Act. This can occur in several different ways, including, as under Section 12B, by listing a class of securities on a national securities exchange, which captures companies that have conducted IPOs in the United States on the NYSE or NASDAQ, or under Section 12G, by meeting certain statutory thresholds with respect to the amount of total assets and the number of total shareholders of record, or under Section 15D, by having an effective registration statement under the Securities Act, such as a shelf registration statement or other registration statements. It's important to note that an issuer is not subject to Exchange Act reporting obligations under more than one section at a time. For example, reporting obligations under 12B, by virtue of being listed on the NYSE or NASDAQ, suspend any other reporting obligations under another provision of the Exchange Act, such as 12G or 15D. However, if the Section 12B registration is terminated, any other previously suspended reporting obligations under the Exchange Act may be revived. This is important and crucial because you need to terminate or suspend reporting obligations under all relevant Exchange Act provisions. So once you start with your Section 12B delisting and deregistration, you have to evaluate under the other provisions which may trigger reporting obligations whether or not you need to take action and proactively deregister under those provisions. What we've set forth here on this slide is the delisting and deregistration timeline and process summary. We're going to go through each of these steps in detail, but I thought it'd be helpful to have it set in one slide so you can see exactly what happens when and exactly how long the process takes. As you can see, the process takes 110 days unless there's earlier intervention from the SEC, which is very rare. So typically count on 110 days from start to finish of delisting and deregistering. We'll start first with talking about delisting and deregistration under Section 12B, steps taking down your securities from the NYSE and NASDAQ, and then deregistering under 12B as well. Each of the exchanges have their own set of rules, but thankfully they're almost identical, and they all tie back to Rule 12D2-2C of the Exchange Act. The first step in the delisting and deregistration process is providing written notice to the exchange of the intent to withdraw a class of securities from listing and or registration. Simultaneous with that, the issuer needs to publish a press release providing the notice of delisting and the intention and rationale for withdrawal, and they have to publish this press release on the company's website for the duration of the delisting process, so for the full 110 days. In addition to that, on the New York Stock Exchange, the issuer needs to provide its board resolutions authorizing the delisting, and both issuers need to file a Form 8K if you're a U.S. registrant, and a 6K if you're a foreign private issuer announcing the delisting. Before you can file the Form 25 with the SEC, you have to have had your notices up for at least 10 days. So once you file your notification, it has to run for 10 days. After that 10-day period, you can then file your Form 25 to begin the full delisting process with the exchanges and the SEC. Once the Form 25 is filed with the SEC, the delisting occurs automatically after 10 days. The Form 25 conveniently also serves to withdraw the class of securities from registration, which becomes effective 90 days after its filing. Once that's effective, the issuer's reporting obligations under Section 12B of the Exchange Act are then terminated. As mentioned previously, the termination of an issuer's Exchange Act reporting obligations under Section 12B may revive the issuer's Sections 12G reporting obligations, but only if the class of securities to be deregistered was listed on NASDAQ prior to August 2006, or there are more than 300 shareholders of record of the class of securities to be deregistered. If the issuer has fewer than 300 shareholders of record, Section 12G deregistration is effective by operation of law. But if not, and you have more than 300 shareholders of record, to terminate the revived reporting obligations under Section 12B, the issuer must file another form called a Form 15 with the SEC. The Form 15 can only be filed after the Form 25 is effective. Therefore, the earliest the Form 15 can be filed is 10 days after the Form 25 is filed. The Form 15 becomes effective 90 days after filing, unless the SEC allows for earlier effectiveness, which, as I've mentioned previously, is quite rare. However, the filing immediately suspends the issuer's periodic and other reporting obligations under 13A, for example, any annual reports, 10Qs, or 8Ks for U.S. registrants under the Exchange Act. Once we've taken care of the deregistration under 12G, if it is in fact applicable to the issuer, we have to look to the other triggers for reporting obligations under the Exchange Act, such as 15D. So, the termination of the issuer's Exchange Act reporting obligations under 12B may also revive the issuer's Section 15D reporting obligations if the issuer has an effective registration statement on file with the SEC. We would note that once an issuer is registered under 15D, the issuer's reporting requirement can never be terminated, except under one circumstance, which we'll talk about in a later slide, but its obligation can only be suspended. Now, deregistration under 15D can happen automatically and also voluntarily. We'll talk first about the automatic deregistration. So, you're automatically deregistered under 15D if an issuer has a class of securities registered under Section 12, or there are fewer than 300 shareholders of record of the class of securities subject to registration on the first day of any fiscal year other than the year in which the subject registration statement became effective. If an issuer's 15D reporting obligations are suspended, but the issuer later does not meet the record holder and asset eligibility thresholds for suspension on the first day of the subsequent fiscal year, the issuer's reporting obligations under 15D will be revived. So it's important that the issuer always monitor its record holders to make sure it meets the requirements. Otherwise, reporting obligations may not be suspended. So what we're seeing here is a policy direction taken by the staff that if you exceed a certain number of shareholders, it's indicative that there's enough U.S. interest in the U.S. equity, that they're going to compel additional information flow to these shareholders and the public. If you go below the number, then it's suspended. If you go above it, then it's revived. So you continually have to monitor and watch the time frame of when you're monitoring to make sure that you don't have an obligation that you otherwise thought you didn't have. Voluntary deregistration under Section 15D is done under Rule 12H3 of the Exchange Act, which was introduced in March 2010. 12H3 permits an issuer to suspend its Section 15D reporting obligations voluntarily if it files a Form 15 and meets the following conditions. 1, it has to be current in its Exchange Act reporting for the last 3 years and the stub period prior to filing the Form 15. And 2, the registered class has either A, fewer than 300 holders of record, or B, as at the end of the company's last fiscal year, fewer than 500 shareholders of record and assets less than US $10 million. It's important to note that the issuer only needs to count the number of registered holders on its shareholder list, and it's easier to achieve this than some may achieve because what we're looking at here is the record holders, and some of these are in street name or in broker-dealer name, and you only have to look to that. You don't look through that to the number of beneficial holders, but only to the record holder. Now, a scenario when you would 15D voluntary registration typically would take place would be during an abandoned IPO. So you have an effective registration statement, but you haven't sold any securities off of it, or the issuer has been acquired by another company, and effectively it only has one shareholder, meaning the acquirer. H3 is not available at all times. For example, it's not available to an issuer if the registration statement became effective in the fiscal year for which it seeks to suspend reporting, or it's had a registration statement updated by 10A3 of the Securities Act. For example, if you have a registration statement that's effective and on file with the SEC, and you're incorporating by reference your periodic filings, once you update that with an annual report, for example, under 10A3, you can't suspend your reporting obligations during that year. Also, an issuer may not rely on the fewer than 500 record holders and the US $10 million in assets rule if the registration statement went effective or required a 10A3 update during the 2 succeeding fiscal years. So what we're really getting at here is you have a live registration statement and you're continuing to update it. There's the presumption that you need to be providing information to shareholders, and the SEC is not going to allow you to suspend that reporting requirement while you're keeping these registration statements alive and updated. Now, in March 2007, the staff implemented some special deregistration regime for foreign private issuers, and this was in large part to draw in more foreign private issuers to the U.S. capital markets, particularly because the barrier to exit was too difficult, and they didn't want to deter foreign private issuers who were listing in the U.S. Because of the difficulty in getting out of the reporting requirements. So Rule 12H6 allows foreign private issuers to terminate, not suspend, terminate their reporting obligations under 15D or deregister a class of securities under Section 12G if they satisfy the following 3 conditions. First, they have to be current in their periodic reports under the Exchange Act for the last 12 months and have filed at least one annual report. 2, the class of securities of the foreign private issuers sought to be deregistered must not have been sold, subject to certain exceptions, to a registered public offering in the 12 months leading up to deregistration. And 3, foreign private issuer must have maintained a listing on an exchange in the foreign private issuer's primary trading market for at least the 12 months preceding the deregistration filing. So if the FPI can meet these 3 conditions, there are 2 ways it can then terminate its reporting obligations under the Exchange Act. The first, through an average daily trading volume threshold method. So what the ADTV method allows is that if the ADTV in the United States is 5% or less than the ADTV on a worldwide basis for a 12-month period, then the staff views that as indicative of not sufficient volume trading in the U.S. for there to be an interest for that issuer to be providing and continuing with its disclosure and public disclosure obligations of the Exchange Act. So if you have de minimis volume in the U.S., you can terminate using this mechanism. You could also terminate under the record holder threshold method. So if you have less than 300 record holders on a worldwide basis, or less than 300 record holders who reside in the United States, that's indicia of not sufficient shareholder interest in the equity, and it allows a foreign private issuer to terminate its reporting obligations under 15D. The process for deregistration for a foreign private issuer is quite simple. One, you file a Form 15F, and like the Form 15 and the Form 25, this is a very simple form, one-pager, with very little supporting documentation. So you file the Form 15F, and once your Form 15F has been filed, the foreign private issuer's reporting obligations under the Exchange Act are immediately terminated. So now that we've walked through the delisting and deregistration process under the most common routes to registration that would trigger reporting obligations under the Exchange Act, before we even get into that process or issuers start considering that, we need to look at, we have other documents and contracts an issuer may have in place which may be directly impacted by a delisting or deregistration. So we would advise that an issuer take stock of any registration rights agreements, shareholders agreements, or debt instruments which may be impacted by failure to maintain a listing. For example, following a delisting and deregistration, a company may no longer be able to comply with any existing obligations to register privately placed shares under any previously agreed registration rights agreements or shareholder agreements. In addition, as many of you know, certain debt instruments may have covenants require maintenance of a listing. So if you have a maintenance covenant, a covenant which requires you to maintain a listing on a nationally recognized exchange, if you no longer maintain that listing, it certainly would be a breach covenant, which could rise to an event of default if the event of defaults take into account that breach. And any event of default could result in an acceleration of that debt. So it's very important to make sure you review these agreements early before you embark on your delisting and deregistration exercise. I'll stop there and hand it over to Billy Au, who's going to talk about secondary listings in Hong Kong.
The status of the Act is currently unsettled, and no final rules have been adopted. Prior to undertaking a going private transaction and a delisting and deregistration exercise, as previously shared with the audience, a prudent and proactive first step for a U.S.-listed Chinese issuer would be to consider a secondary listing in another jurisdiction closer to home, such as Hong Kong. A mechanism for exchanging ADRs listed in the United States with ordinary shares listed in Hong Kong should also be considered and largely favored by shareholders. At a minimum, this would give the U.S. public equity a second home and optionality for shareholders to move exchanges. It also would provide a clear equity and liquidity framework in the event of a U.S. delisting and could lower the risk and cost of any taking private transaction with respect to U.S.-listed equity. If an issuer chooses Hong Kong as its only listing venue, it is a primary listing. The Hong Kong Stock Exchange, as opposed to any other overseas stock exchange, is its primary listing regulator. In a dual listing situation, the Hong Kong listing may be either primary or secondary. To qualify for a secondary listing in Hong Kong, the issuer must maintain a primary listing on a recognized overseas stock exchange, which the Hong Kong Stock Exchange recognizes as providing equivalent standards of shareholders protection. However, if the majority of trading in an issuer's securities is likely to be on the Hong Kong Stock Exchange, it is generally expected that the Hong Kong listing should be primary. The Hong Kong listing rules give greater latitude in a secondary listing in respect of listing requirements and ongoing obligations such as the contents and accounting standard of an issuer's financial reports. An issuer may seek for a secondary listing in Hong Kong with an offering of new shares, or its shareholders may sell existing shares or combination of both by way of an offering to achieve a broad shareholder base in Hong Kong. A secondary listing can also be achieved by way of introduction, by migrating certain number of shares traded on the primary listing venue to the secondary listing venue. In essence, the vetting process is the same in both cases, with offering or without offering, but in a secondary listing by way of an introduction, no offering or other marketing arrangement are required. In 2018, the Hong Kong Stock Exchange introduced and implemented a concessionary secondary listing route. An issuer seeking a secondary listing on the Hong Kong Stock Exchange by this concessionary secondary listing route under Chapter 19C of the Hong Kong listing rules is expected to be an innovative company, primarily listed on New York Stock Exchange, LASDAQ, or the main market of the London Stock Exchange premium listings, each being a qualifying exchange, with a good record of compliance for at least 2 full financial years, have a market capitalization of at least 10 billion Hong Kong dollar at the time of secondary listing in Hong Kong. The Hong Kong Stock Exchange consider an innovative company for the purpose of a secondary listing in Hong Kong would normally be expected to possess more than one of the following characteristics. Its success is demonstrated to be attributable to the application to the issuer's core business of new technologies, innovations, or a new business model, which also serve to differentiate the company from existing players. Research and development is a significant contributor of its expected value and constitutes a major activities and expense. The issuer's success is demonstrated to be attributable to its unique features or intellectual property, and it has an oversized market capitalization in tangible assets as compared to its tangible asset value. The Hong Kong Stock Exchange will review the facts and circumstances of each case to determine if an applicant for secondary listing has demonstrated that it is an innovative company. The superficial application of new technology to an otherwise conventional business will not be sufficient to demonstrate the characteristics above. For example, the Hong Kong Stock Exchange may consider that an applicant for secondary listing in Hong Kong that operates a retail business with an online sales platform may not be suitable to list by the concessionary secondary listing under Chapter 19C of the Hong Kong listing rules if it does not exhibit other distinctive features or characteristics. A U.S.-listed Chinese issuer or issuer with a weighted voting rights structure will be required to have a minimum revenue of 1 billion Hong Kong dollar in its most recent audited financial years, if its market capitalization is less than 40 billion Hong Kong dollar. This is important to a U.S.-listed Chinese issuer with a center of gravity in Greater China, as they were not eligible for a secondary listing in Hong Kong before this new concessionary secondary listing route under Chapter 19C of the Hong Kong listing route. Only those U.S.-listed Chinese issuers listed before the 15th of December 2017 will enjoy certain concessions in connection with equivalent requirement in respect of the issuer's constitutional document under the Hong Kong listing rules. In other words, it is not mandatory for the U.S.-listed Chinese issuer to amend its constitutional documents to meet the Hong Kong key shareholder protection standards, and they may adopt the method specified in the Hong Kong Stock Exchange jurisdictional guidance. The U.S.-listed Chinese issuer will be able to secondary list with their existing VIE structures in place, subject to the provision of a PRC legal opinion that their VIE structures comply with the relevant PRC laws, rules, and regulations, and certain additional disclosures. A VIE structure refers to a structure whereby an entity established in the PRC that is wholly or partially foreign-owned exercise de facto control over a PRC domestic operating company, which holds the necessary license to operate in a restricted sector. The U.S.-listed Chinese issuer in the internet-related, education-related, and other restricted business sectors usually have a VIE structure in their group structure. The U.S.-listed Chinese issuer will be able to list in Hong Kong with the existing weighted voting rights structures and will not have to comply with the ongoing weighted voting rights safeguard under Chapter 8A of the Hong Kong listing rules. Such safeguards, such as the restriction not to increase the proportion of share with weighted voting rights after listing, or the requirement for certain resolutions to be subject to voting on a one-for-one shares basis, except for those are subject to disclosure requirements. For those U.S.-listed Chinese issuer listed on or after the 15th of December 2017, will have to comply with the existing Hong Kong listing rule requirements in relation to key shareholder protection standards, VIE structures, and voter rating rights safeguard. A U.S.-listed Chinese issuer applying for a secondary listing under the concessionary secondary listing route under Chapter 19C of the Hong Kong listing rules would be entitled to make a confidential filing of his application, which is different from those listing applicant under other regime under the Hong Kong listing rules. If a U.S.-listed Chinese issuer fails to meet its obligation under U.S. regulations and listing rules, for example, fail to meet the requirements of the Act, if passed, it would be a non-compliance event on its primary listing venue. The Hong Kong Stock Exchange would likely review this non-compliance event on a case-by-case basis as to whether it would affect the secondary listing status. Hong Kong Stock Exchange will regard the majority of trading in an issuer's shares to have been moved to Hong Kong on a permanent basis if 55% or more of the total worldwide trading volume by dollar value of those shares, including the trading volume in deposit received issued on those shares over the issuer's most recent financial years take place on the Hong Kong Stock Exchange. When the bulk of the trading is considered migrated to Hong Kong on a permanent basis, the codified waivers granted to the U.S.-listed Chinese issuers above will cease to apply. This issuer would, on a case-by-case basis, be granted only waivers that are commonly granted to dual partner-listed companies, such as those related to reporting accountants' independence, qualifications, and company secretary qualification and experience requirements.
Thanks, Billy. One point to note is that, overall in this entire presentation, it seems very binary that you have to exit the U.S. and do another listing in Hong Kong or find another listing venue. But there is a third way, and that would be one to maintain your listing in the U.S. You'd have a secondary listing in Hong Kong and give the ADR holders in the U.S. a mechanism to exchange their ADRs for Hong Kong ordinary shares. Now, this is obviously the formulation we've seen for JD.com and NetEase, and this is certainly an option for U.S.-listed Chinese issuers to take. So, I just wanted to make sure we leave you with the impression that there are options here that are softer than just exiting one and entering another. You could sort of have your foot in both places until the legislation clarifies and parties can make a more a decision with more facts.
Thanks, Tom. Thanks, Billy. That was a great discussion. I think that one of the things that's difficult about doing a presentation like this is trying to cover such a broad number of topics. I think we could have done an hour or two just on secondary listings in Hong Kong, and I think that we could have done an hour or two on deregistrations in the United States. But trying to put this all in one place, because these are the ways that CFOs and other market participants are coming to us and just discussing options in these early days. Again, the draft legislation in the United States is still in draft, and it's uncertain how that will land. But these discussions are constructive as people think about ways in which they need to be adjusting where their equities are traded, and these things obviously take time. The recent deals that Tom referenced with JD.com and NetEase and others obviously weren't executed on a moment's notice. They've been in plan for a while. And these are always, and this is something that everyone will know, these are always subject to market conditions at the time that you launch one of the offerings. And so one of the difficulties there is that with the global pandemic and with increased market volatility, those windows tend to open and close even more rapidly these days than maybe they did in the past. So those are the types of things that we're talking to our clients about pretty regularly, and we're happy to answer any questions or to go into greater detail.